So, Mr. Wehrman, let me place the question that I should have made to Alex. How are amendments to patent claims ruled in India? What are the conditions stipulated by the Indian Patent Act to amend the claims of a patent application regarding the scope of the amendments and the time limit to do it? You have the floor. Thank you.
Thank you. So I'd like to first thank Dr. Porto for the introduction, and truly it's an honor and a privilege to be able to share some of my thoughts on claim amendments and the evolving jurisprudence in India, and to be doing it on the eve of World IP Day. It's like the cherry on the cake. So this is, of course, a very important topic. I'd like to briefly mention, I mean, we have a provision which is somewhat similar to Article 123 of the EPC. That is the provision of Section 59 of the Patents Act. As it stands, it's actually a little complicated. But before I get to, and that's actually the provision that talks about, the nature and the scope of amendments. But before I just touch upon that, I think, a couple of, the provisions which are just before Section 59, which is sections 57 and 58, they also deal with amendments, and they lay down the procedure and the timelines. And since that's a fairly easy topic to get to, I think I'll just quickly go over that, and then I'll come on to the focus more on the nature and scope aspect. As far as the procedure goes, it's a fairly straightforward procedure. Whether it's a pre-grant amendment or a post-grant amendment, there's actually a standard form that's called Form 13, on which we make the amendments. It's actually a request. It's a request to the Patent Office to make voluntary amendments. It basically contains certain bibliographic details, but more importantly, I think what's really important in the form is you have to specify the reason for making the amendments. So it could be one or more reasons, which could be, and it could be as simple as something as a correction of a typographical error, or a correction of an obvious mistake, or maybe perhaps you're introducing new claims to explain the invention in a more lucid manner, but some reasoning needs to be given. It remains the same whether it's pre-grant or post-grant. Essentially, there's no time limit which is fixed. So, when you want to make voluntary amendments, typically that can happen soon after filing of the application. Now, filing is a bit tricky because Section 57, and you look at the other provisions of the Act, when you file an application or you enter national phase in India, typically you're not allowed to undertake amendments. So you have to file an application with the original PCT claims or the claims that have been amended under Article 19 or under Article 34. If you want to make any amendments, you will have to file that formal request on Form 13, and whether that concerns merging the claims or whether that concerns adding new claims, only deletion of claims is permitted at filing. So that might be at variance with some of the other jurisdictions. So that's typically what happens at filing. Post-filing, like I said, there's really no stage essentially when you need to request. So you're given a certain time frame. You have about 17 months after you've entered national phase to request examination of the application. Clients and applicants generally choose to make some voluntary amendments at that stage, and that's looking at some of the amendments which have taken place in counterpart applications. And then you could essentially, even after, so a first examination report or a first office action is issued by the Indian Patent Office. That is essentially the time when you could request for amendments, and you don't really have to file the formal request. So you could do voluntary amendments, and you could justify the amendments as being in response to the objections which have been raised. So very similar to Article 123(1), except that you're not, it's not voluntary. It's in response to we call it that you're responding to the objections in the first examination report. Post-grant is slightly trickier. It's more difficult. I would say that, obviously, when you file this formal request, there's an official fee component which is associated, and that sort of doubles up after post grant. And if the amendments are substantive after post grant, they will be published in the official journal of the Patent Office. Once they are published, there's a 3 months opposition window which is given. So any person who is interested in opposing the amendments can do so in writing to the Patent Office, and you have that 3 months window. And then, of course, once there's an opposition, the controller will hear both the parties and then finally decide whether the amendments should be allowed or not. So that's pretty much as far as the procedure and the timelines are concerned. Now I'll come to Section 59 straight away in the interest of time. Section 59 is actually a very ambiguously worded provision, and it's somewhat similar to Section 123, but it's, like I said, given that it's ambiguously worded, it's sort of difficult to sort of decipher what the lawmakers actually intended. And so if I were to distill that provision down, I'd say there are 3 main features, or there are 3 main elements to that. First is that the amendments have to be in the form of a disclaimer, a correction, or an explanation. It's interesting that the term addition does not find mention here, and that's typically when you're adding claims, you hit into an objection under Section 59 of the Patent Office because they say addition does not really fall under one of the 3 categories, even though you may try to explain, you try to tell the Patent Office, it's by way of explanation. It's very difficult to convince them when you're trying to add new claims. So that's one part. The second part of Section 59 states that it's the amendments have to be for incorporation of an actual fact. Now, what exactly does incorporation of actual fact means? That's anybody's guess, because it's, again, like I said, it's very ambiguous. What is not an actual fact? I think that's something that the courts might deal with in due course, but definitely not happening right now. The third and the most important part, it says that amendments to claims must fall wholly within the scope of the claims prior to the amendment. Now, and this is something which is similar, I won't say identical, but something similar to what Article 123(2) of the EPC states. But again, what does this expression fall wholly within the scope mean? That's essentially what was somewhat clarified in the judgment that I was that one of the matters that I'd argued, and I was supported by a wonderful team with me. The Allergan decision that you had rightly mentioned, this particular phrase was interpreted to essentially state that claims cannot be read in isolation. So you have to look at the specification as well. So when you're looking at ascertaining the scope of the claim, it's not just the 4 corners of the claim. Apart from that, you've also got to look at the disclosure. So I'll leave that bit of discussion for a little bit later, but I hope that's try to clarify what the procedure, the timelines, and what the nature and scope are as far as Indian law are concerned.
Ankush, let me ask for a clarification. You see that in Brazil, there is a difference between the allowed amendments that you can make before the request for examination and after. Is there such a distinction in India too?
No, actually, I mean, if you are trying to, it's advisable that if you want, typically, like I said, what generally happens is that any amendments which are considered by most applicants or clients they take place along with the request for examination. So it's actually a good time to consider if you wish to introduce some claims. Of course, there's always you always anticipate a Section 59 objection for any new claims that might be added. But if you are looking to introduce some claims with new aspects, which perhaps have not been covered in the original PCT claims or at the time of filing, you could consider doing that at the stage of examination, at the stage where you're requesting examination. And, depending on, I mean, it could be, it's a double-edged sword, so to speak, because if the controller determines that the amendments, and of course, it again comes down to that Section 59, that phrase which says falling wholly within the scope. So if you're trying to alter the scope, there is a possibility that the controller, who is the officer at the patent office, he may not consider the amendments at all. So there is that risk of introducing new claims, but it's certainly possible to do that at the stage of requesting examination. But it's not really that the new subject matter cannot be introduced. Of course, the threshold to overcome Section 59 is it just gets more and more difficult the later you try to introduce new claims.
What is the usual advice related to the submission of amendments to the claims during examination?
Thank you. Amendments, actually, we, as a matter of practice, I'd say that given the the vagaries and the complexities which are associated in surrounding amendments in particular, a one-size-fits-all situation doesn't really work. So when whether it's voluntary amendments, I think and when I say we, I'm obviously referring to the attorneys at the firm. The attorneys would, you'd study a case, you'd look at the merits of the case. I think we'd also try to come up with a strategy, because under Indian patent law, there's a long list of exclusions, and you don't really want to get into a situation where you're trying to amend it in such a way that, for instance, you have subject matter that is not patent eligible. You try to amend it in a way that you trigger an objection under Section 59, and then the amendments are not being allowed. So for each case, I think a strategy needs to be formulated. The Indian Patent Office also has certain restrictions in the sense that claims, once they are deleted, many of the controllers, the officers who are there at the Patent Office, they don't allow reinstatement of deleted claims. The opportunity to amend, has to be looked at very carefully. We also many a times look at the counterpart applications, see what kind of amendments have been preferred in counterpart applications, whether it's really beneficial to do that, keeping Indian law in mind. Really, you'd have to look at overall what are the merits of the case and whether amendments are really necessitated. And we'd only advise amendments if they're absolutely essential, or we believe that they're sort of going to expedite examination, or unless the client is very insistent that, or the applicant's very insistent that we must go ahead with, because typically you have the opportunity to amend when you're filing a response to the office action. And if those amendments are deemed unsatisfactory, then the Patent Office will again issue what we call a hearing notice. So you have oral hearing proceedings before the Patent Office, where you get another opportunity to make further amendments. So from that perspective, voluntary amendments are something that we sort of we don't really sort of push or advise unless they're absolutely essential.
I have one question from one participant, which is just on the side of the issue of amendments, but I think it's also important. He's asking about whether the Indian Patent Office has any restriction on claims filed in divisional applications, possibly similar to the restrictions in Brazil. So perhaps, Ankush, you could give us just a very brief response to that. And Monique and Alex can also comment on whether there is any difference about the kind of changes you can do to your claims if you decide to divide the patent application instead of trying to amend existing claims. Please, Ankush.
Thank you. Actually, we've unfortunately had a decision from the Delhi High Court on this very issue. And I am not in agreement with what the court finally had opined, but it turned out. So I'd take a few minutes to just briefly explain the facts. What had happened was that we tried to we amended the claims in the parent application, and essentially it kept hitting the Section 59 objection, like I mentioned. The controller was insistent that it's not falling within the scope of the original claims. And so we decided to pursue those claims, the amended claims, we decided to pursue those in a divisional application. And unfortunately, our arguments were that since the amendments had never been considered, essentially novelty, inventive step, all these, clarity, definitiveness, nothing had actually, the claims had never been examined, other than to say that the amendments were not considered allowable. And so we tried to push those in a divisional application, but the court essentially held, and so this goes back to a particular provision in the Act, which is Section 16 of the Act, which deals with divisional applications. So under our law, you could file divisional applications on your own, which is suo moto, or you could file a divisional application if an objection is raised by the Patent Office. Now, the number of applications that actually go through on the suo moto basis is actually very slim. It's that is not to say we've been successful in the past. There have been some divisional applications that have now been allowed. The underlying criteria, whether it's suo moto or it's an objection which is raised by the Patent Office, is that there has to be a plurality of inventions. And so in this judgment that I was talking to you about, which came out from the Delhi High Court, the Delhi High Court actually held that the plurality of inventions is actually to be looked at in the claims, the original claims of the parent application. So when you're dividing an application, essentially that plurality, if you're making even a suo moto application, you should be able to establish plurality from the original claims of the parent application. So that's essentially a restriction which has been placed, which of course I'm not in agreement with, because the plurality, if you read the provision, and again, Section 16 is one which is it's a fairly clearly worded provision, but the way it has been worded is the objection, as far as the plurality objection goes, that is somewhat more tied up with the with the controller's objection, and the fact that you're reading that plurality into the original claims of the parent application seems to be a very restrictive interpretation. So suo moto, as long as you can establish that there is another invention that exists, and it not necessarily in the claims of the parent application, but even if it's there in the disclosure or the specification, in my opinion, that should be good enough. But unfortunately, that's not what the Delhi High Court thought. So,
okay, thank you, Ankush.
And just to add on to that, we actually pressed the applicant to sort of, because this was a very important decision which had come out, and we actually tried to convince the applicant to go in and appeal, but for whatever reasons, the decision was not appealed. So that's the current standing as it stands.